People often ask me whether it is possible to get anticipatory bail in a serious offense, just like anticipatory bail in 376 matter or in 302 murder case. So first let me tell you, there is no bar in the entire law in which case the anticipatory bail can be granted or in which case it cannot be granted, except for certain special laws where the concept of anticipatory bail has been ruled out, it has been taken away by the legislative body. For example, the SCST Act. So it also depends upon the state where the anticipatory bail, the law related to anticipatory bail, has been taken out by the state government. In the rest of the matters, when there is no specific bar, anticipatory bail can be granted. The Supreme Court since 1980s have already been stating that the bail is the rule and jail is the exception, and has laid down various criteria in how the bail application should be treated, how it should be decided by the court. In 1980, the Honorable Supreme Court in Gurbaksh Singh Sibbia's case has already held that the concept of anticipatory bail comes from the Article 21 of the Constitution, and it is even not necessary to get the FIR registered before filing of the anticipatory bail application, meaning thereby the registration of the FIR is not a precondition or a pre-mandatory condition for grant or the non or the dismissal of the anticipatory bail application. However, in serious offences, just like murder case or a rape case, the gravity of the offence plays a very crucial role while deciding the anticipatory bail application. Before we get into the other judgments, let me tell you what is the meaning of anticipatory bail. Anticipatory bail is an order passed by the concerned court under section 438 CrPC, which directs the person who filed the application to be released on bail as and when that person is arrested. Obviously, that person should be able to give the surety and security and has to comply with the certain other conditions also. In serious offences, generally the tilt of the court is not to give anticipatory bail, not to grant this kind of orders in favor of the applicant, and that too at a very early stage. However, in so many cases, the Honorable Supreme Court has propounded this principle that bail is a rule and jail should be the exception. The arrest of the person should be the last resort. In 1980, the Honorable Supreme Court in Gurbaksh Singh Sibbia's case has already stated that the anticipatory bail can be granted if there is a reasonable apprehension of getting arrested in a non-bailable offence. In 2010, the Supreme Court granted anticipatory bail in a 302 murder case in Siddharam Satlingappa Mhetre's case. And the Supreme Court laid down guidelines as to what an investigating officer should do at the time before the arrest of the person. Why the arrest of the person should be the last resort for the police. It can be for the just and proper investigation of the case. It can be if the accused is able to flee from justice and there are apprehension that he would flee, or if there are any apprehension that he would tamper with the evidence, he would try to influence the witnesses. In those cases, the anticipatory bail should be withheld. However, in rest of the cases where there is no such apprehension that the person will not appear before the trial court, the anticipatory bail should be granted. In 2022 itself, in SK SUFFIYAN's case, the Honorable Supreme Court has granted the anticipatory bail in a murder case based on the principle which were laid down in 1980 in Gurbaksh Singh Sibbia's case. Now you can find all these three judgments, a link in the description box. You can download these judgments, and if you have any questions you can ask me. I'll try to answer those questions, and I'll see you in the next video. We'll talk about some other important judgment passed by the Honorable Supreme Court related to the serious offences itself.